afternoon and good morning, I guess, for those of you who may be listening in from the West Coast. My name is Lynn Clements. I am the Director of Audit and HR Services at Berkshire Associates. For those of you who don't know me, Berkshire is an affirmative action and HR consulting firm. We do a lot of pay analytics and other sort of high sophisticated people analytics work, as well as help federal contractors prepare affirmative action plans. I am very excited to be hosting this webinar with our legal partner, Berenzweig Leonard. We've hosted a couple of other webinars with them for our clients, mutual clients, and also friends of our firms. And so I'm really excited today to join you again with another session with Berenzweig Leonard. And without further ado, because we have a lot to cover today, we're going to spend some time the next hour talking about navigating non-competes and non-solicits, and how, if they're done correctly and strategically, they can really protect your company and your business assets. Just in terms of housekeeping, the session is being recorded. We will make the recording available. And in addition, if you have questions, we welcome them. So we would love to try to be able to answer any of your questions. You can drop them in the Q&A box at the bottom, and the PowerPoint will also be available. So with that, I want to introduce you all to Seth Berenzweig. He is the founder and managing partner of Berenzweig Leonard, a law firm in Virginia, so very close to our offices here in Maryland at Berkshire. His legal practice centers on traditional business law, government contracts, and compliance matters, while expanding his professional reach to represent companies in the high-tech space and sports and entertainment. He also frequently appears as a legal analyst on national television covering business law issues. And I have seen him myself, so I know that is true, which means he's going to be a great presenter today. So we are super excited to have Seth join us. I'm going to actually just turn it over to Seth to say hello and get started. I will monitor the question box and sort of guide the conversation, but Seth is really the expert in this area, so I'm really excited to have him share his knowledge with all of you.
Thanks so much. It's really a pleasure to be here, and really delighted to join you for this hour. We'll have a lot of areas to cover, and we'll be moving through a number of areas that we'll cover, but also go well beyond non-competes, non-solicits, and going through a lot of the basic building blocks of things that flow into the HR and employment space, and to help the company and HR professionals to be aware of issues, be aware of things that are important in documents, but also to be aware of really important dates that are coming up on a number of hot button topics. That'll be something that I'm really looking forward to presenting today. So without further ado, if it's okay, I'd like to jump right into our first topic, which is discussion of non-compete agreements. Non-compete agreements really are one of the basic predicates and one of the real foundational building blocks of employment agreements. And quite frankly, they flow through a lot. Not only that, but they can also flow through joint venture agreements, teaming agreements, and the like. So this is something that really is part of the lifeblood of the company. The basic legal standard of how these things are weighed to determine whether or not they're enforceable is really what just about all states call the reasonableness test. And it balances and co-balances the question of whether or not it is no broader than necessary to protect a legitimate business interest, whether it is unduly burdensome and broader than necessary in curtailing the activity at issue. So I won't get you too far in the weeds on that, but as you can imagine, asking whether something is reasonable in the legal world is kind of like asking how many angels can dance on the head of a pin. But these are things that really attach some common misconceptions, because sometimes companies think, well, we're going to really just go muscular here and we're going to go real hardcore. If you go too broad, it's unenforceable. So this is something that can be a very effective thing to use and is very commonly in effect. Also, you can anticipate times where your company will be looking at it from the other side, because there will be instances where you want to hire a rock and roll employee, and then all of a sudden you get a little bit of a lovely nastygram from the former employer saying, guess what? They signed up on a non-compete. And then, so there's different angles and different ways in which you can get wrapped around this axle. One big change that is huge, and one of the main things that I'd like to highlight for you today, is beware of California. If you're an HR professional, that's probably not the first or last time you've thought of that. However, California has adopted, beginning January of this year, a revised and broadened statute requiring employers that have any employee or employees in California to provide a written notice to them by not later than February 14th, which is literally just a couple of weeks away, notifying them that their non-compete in the state of California is non-enforceable. And that if you don't do that, guess what? You are on the hook for up to $2,500 in penalties. So as you can imagine, this is kind of a big deal. This is something that will come up again when we start talking about non-solicits, because the same notion applies. But it's really important to work with your corporate counsel or your HR counsel, because first of all, how does this apply to your workforce is not only dependent upon the status and locations of your employees today, but also where they may be 1 or 2 months from now. In this post-pandemic world, even aside from the fact that there are people working off-site at a customer, people might be moving periodically, and you will want to let them know that you want them to provide you with notice. Say, for example, 30 days notice of when they intend to move, because as we know, employment law is largely a creature of state law. And this is one interesting example. Not only does California hit this really hard on the nose with regard to some real big and immediate changes that will directly impact the company, but the state of Washington is going through a class action lawsuit that may end up in the same place. So the bottom line on non-competes is there's a lot of activity around this very hot area. It sounds like kind of a dry, boring topic, but it is until it's not. So stay ahead, lean forward, and be aware of what jurisdictions apply and what laws apply. Having your counsel take a peek at that and lift up the hood is something that could really help avoid potential pitfalls and problems down the road. Now, if you're saying to yourself, okay, that's a little bit complex because, you know, we're a government contractor and we're in over a dozen sites. So are you saying that I have to look at and consider and balance lots of different state laws? The answer generally is yes. However, as we see on the next slide, just wait, there's more.
Yeah, and Seth, before we go to the next slide, actually, I have a question.
Sure. Absolutely. Absolutely.
And I think this is a great question. So thank you to whoever raised it. What are common mistakes employer make when including a non-compete provision in their employment agreements?
Sure, that's a great question. So typically, one of the most common mistakes that an employer makes is to provide a statement that is seemingly ordinary, but that generally says that this is an individual that cannot serve as an employee at a company that is in competition with the current employer. And it is not without more specific limitation. In other words, this is something that we lawyers say is subject to the so-called janitor's defense, which says that, okay, well, that means that he can't even go be a janitor over at Lockheed or Oracle or what have you. So a typical error is to say you can't work for an employer or you can't work for a competing company. But if you don't make it job specific, if you don't make it task specific to the department and the role that that person is doing, then there's going to be a pretty fair chance that that's going to be deemed unenforceable. And frankly, you may even find that out right away because a lot of these cases start out in a hot litigation, injunction realm, where you have to show a likelihood of success on the merits, and the other side will come out right away and say it's not even enforceable. So that's one of the common areas that I see coming up here.
Yeah, I spent a couple years as a young associate in the Rocket Docket in Virginia. So I'm familiar with enforcing non-competes and on both sides, either defending them or enforcing them. So, well, I think you were giving a hint to where we're going next. So why don't we go there, which is to talk to the audience a little bit about what the Federal Trade Commission is up to in this area. And before you do, I just want to say, this isn't necessarily a topic that all federal contractors think about in terms of our clients who are really in the diversity and EEO space. But there is so much interest in what kinds of agreements you have with your employers. The OFCCP's new scheduling letter sort of brings this into play. They want to know what agreements you're signing. The NLRB is very interested. And now we have the Federal Trade Commission also interested. So Seth, why don't you tell us a little bit about that?
Absolutely. So typically and historically, non-competes have really been an animal of state law. The FTC here in Washington, D.C., has triggered a proposed rule that would, to a large degree, ban non-competes, which would be within the same general aim and spirit of what is in California. And this would, of course, be a game changer because this would really kind of raise up the bar and the level, if you will, for all of the states. The agency has gone through a so-called notice and comment period. They've been doing that for several months. This is something that will conclude, and we will likely have a final rule out by the April or early May timeframe. So it's a little early, but it's coming up as to whether or not or to what degree this is going to come into effect. But it could be a really big deal. I'll just drop a quick footnote and say the Supreme Court has a case this coming term that may have somewhat of an impact on this because they're going to also be determining under the so-called Chevron rule the extent to which we must or need not provide deference to significant new agency action, but putting that a little bit aside to the moment. There's a lot happening in this space. The FTC may step in, and it may happen within the next couple of months.
Yeah, the Chevron case, I think, has potentially big implications in lots of employment law areas because so many of the agencies we interact with, promulgate rules. And the question is really how much deference do we have to give those rules? So I'm curious if you could maybe speak to, before we move on to non-solicitation clauses, how do you think all of this interest at the federal level is going to sort of potentially change the legal landscape for non-competes? Do you think they will have to be even more narrow going forward? And in particular, it's sort of something you said earlier really makes it challenging, I think, to handle non-competes because historically, one of the ways to make it less broad was to limit it by geography, right? But because everyone can work, so many people can work remotely, geographic limitations can, I think, be difficult. So any predictions about how, particularly the FTC rule or other interests by federal agencies, is going to impact what has, as you said, traditionally been a state law concern?
Yeah, it's a great question. And I think that, it certainly is one of the goals of the current administration to be more proactive and lean forward into protection of employee rights. Regardless of one's, general, political viewpoint or broader impact of that, the Biden administration is really leaning forward into this area, and therefore agencies like DOL are doing it, and NLRB as well. I predict that there will be a rule. It will be published in the spring. It will probably be attacked pretty quickly in the courts. And I think we're also going to have to, as a very practical matter, keep an eye on what happens in November, because if we have a Republican administration, regardless of who's running that, I suspect that they may set this aside. So I think in the short term, we'll probably have a leveling up to more of a California-like standard, if you will. But in the long term, I predict a lot of volatility, and it's going to be really there's going to, buckle in. There's going to be some volatility here. And your legal counsel will be able to help you kind of make shape or sense of it. But I do think in the spring we'll be looking at an activity and a development on this front from the FTC.
All right, so that's a stay tuned, but like everything in HR, complicated and buckle up.
Exactly.
All right, why don't we move on to non-solicit provisions? And tell me the difference, first of all, between a non-solicitation clause and the non-compete clause that we were talking about before.
Absolutely. So typically a non-solicitation clause is in general viewed as a narrower, more precise instrument, if you will, while a non-compete is aimed at broadly keeping former employees from going across the street, if you will, and working for a competitor. A non-solicit is a little bit more narrowly and surgically tailored to require someone to not poach employees, to not try to pull away customers. So it is generally viewed as a more narrow but still very important and fundamental restriction. Some companies, as a strategy, in order to avoid getting, kind of caught in the mud pit with regard to the reasonableness disputes on non-competition covenants, really just plug in non-solicit clauses as, and can be done in certain situations as an effective substitute. Depends on the company and the circumstance, of course, but sometimes it's a strategy used because it's therefore a little bit more specific. This is, of course, one of the areas. The good thing about that is that it is more precise, and it may protect you, especially in the Virginia and DC area in that regard. The bad news is that if you take your magnifying glass and you kind of look out west a little bit and you go again to California and the state of Washington, these are some of the same post-employment covenants and restrictions that are subject to the February 14th deadline in California. That is something that could be up for dispute, because depending upon what kind of controls are put in, the company could argue that it really isn't a non-solicit. So, for example, even the laws themselves say this is not going to affect NDAs, it's not going to affect confidentiality. We're not saying that people can't go and earn a livelihood, but if somebody leaves and wants to poach somebody, other people's salaries and other people's responsibilities and government contracts are subject to a confidentiality clause. That's a way to get around it. So there's some strategies, but again, it's something that is a very dynamic area and could be case specific depending upon where your employees are located. Because although, as we'll talk about shortly, you can control venue in terms of procedurally where disputes are located, you cannot wipe out, you cannot pull away the state substantive laws that would apply to your employees that are located in different jurisdictions.
Mm-hmm. So maybe that this is always an it depends answer, I think, and as is the case in this area of the law. But do you have any tips on how broadly employers could write non-solicitation agreements without running afoul of sort of most state laws, maybe setting aside California and Washington and their notice obligations?
Yeah, and I think this is something that might really arguably apply with respect to non-competes as well. Try to keep it specific to the individual's responsibilities and department. If they are working in a certain department, a certain organization within the broader company, and they have a particular expertise and focus on terms of the kind of work that they do, the kind of solicitations and agencies that they work with. If you tailor it down to something that you need within that lane, I think that you'll probably be on sounder ground.
And just a follow-up question, do most companies provide a list of like if there's going to be a no soliciting clients kind of provision, do most companies provide a list of clients either in the agreement or when a person is leaving, or do you recommend it's more general, like this type of client without naming them? Any tips on that issue?
Yeah, so that's a great question. I think that in theory, it should be done. And if I'm representing a company where they hired a rock and roll new employee or a new employee, and the former employer came in and said, look, here's a non-compete, I would, the first thing I'm going to ask is who are your competitors, and were they disclosed in the agreement? The good thing about disclosing it is that it provides for a definiteness and certainty. The bad thing about attaching it is that it's fluid. So 3 days before the employee leaves, that's a changing list, right? So it kind of cuts both ways, but it's a great question, and there are different practices. I can tell you that from a practical standpoint, most companies do not attach that because they consider it to be fluid, and they would hold that the responsibility of the former employee, which is okay as long as the underlying restriction governing that is not unduly broad, more so than necessary to protect the company's business interests.
So two follow-up questions have come from the audience, and I think they're both good ones, if you don't mind.
Mhm.
A, a listener has an interest in flipping this. So what if you're the employer of the new, of the individual, and the individual has a non-solicit? What are tips for that employer who's on sort of the opposite side of the coin?
Well, I would say, first of all, to have grab some coffee with that person, sit down with them and say, okay, welcome aboard. We're going to do great things, and we're going to go out there and we're going to generate revenue. When we do that, we're going to have to turn some square corners here. So for purposes of compliance, let me know who in our market, in our industry, in our vertical are folks that you've worked with that, according to your restriction, oh, I'm looking at it, and oh, look, it's a 1 year, 12-month restriction. Okay, tell me, who are we restricted from? Identify, and then that way, if it's a non-solicitation of customers, and this person's going to be on a sales leader, you know who not to touch. If they come in and they say, boy, I really loved working with Martha, we should really get her in here. Just review and confirm. If you know what you're working with, then you'll be able to know what to keep on the radar screen. Also, when you do that, you may find out that the list is indeterminate or unreasonable, and then that could lead to broader and other interesting conclusions as well, because it may be unenforceable. So reviewing and assessing, definitely having that helpful conversation.
Yeah, that leads to the rocket docket in
Oh
some
yeah.
instances.
Yeah.
So the other question that came in from a listener, it was related to the California notice requirement that is
Mhm.
pending on February 14th. And they just wanted to confirm that they had not seen that employee-specific non-solicitation provisions were subject to that February 14th notice requirement. And so the question, I think, is, can you just reconfirm whether the February 14th notice requirement applies to non-solicitations, or is that a little unclear?
So it's a great question, and to dig into that a little bit more, the general answer is yes, but the deeper answer is that it is not necessarily a one fit applies to all. So in other words, the statute in California requires notice with regard to these kinds of covenants that are restriction on commerce. Now, of course, thanks to the legislators in California, we have kind of a loosey-goosey legal word salad, right? And the California courts state that will just about uniformly apply to non-competes. It does apply to most non-solicits. However, it depends on the scope of the non-solicit. If it is something that is more focused, for example, on not soliciting business using somebody's confidential information or proprietary data, it might arguably be more based upon a non-disclosure. So the general answer is that most are subject, but it's worth and it would be important to review with your legal counsel, because whether or not it ultimately fits within the definition in the ambit of the California statute, it could be case specific. So it's something that you do need to look at. It could very well apply, but it does warrant further review. Be aware of the February deadline, so that if you're on it now, you should have plenty of time to be able to drill into that and get a quick answer.
Yeah, I mean, this is one area, like so many areas of employment law, but this one in particular, where words really matter. And, you know, as practitioners, as legal practitioners, we're always constantly looking at words. I think there's lots of lawyer jokes about how precise we are with our language.
No
But
doubt.
this area in particular is one where it really matters. And I think, you know, Seth's comments on the California law really highlight that, right? It depends on what your language in your non-compete and non-solicit say. And so that's why it's so important to think about how you're writing that up front. And to really kind of poke holes in it, like, you know, have someone read it. What do you think this means? And because the words here really, really matter, not just in terms of whether it's reasonable or not, but even to your point as to whether it's a non-disclosure, a non-solicit, or a non-compete clause. So I think that's, you know, lawyers love to say words matter, and this is one of those times where they really, really, really do. So should we move on to talk a little bit how you do protect trade secrets, or was there more that you wanted to talk about with respect to non-solicitation provision?
No, I think that that was a good that was a good walk through that area, and I'd be very happy to talk about trade secrets, which I believe is probably on our next slide. So I'd be happy to talk about that. Trade, you know, the main focus for today is to talk about things that matter in terms of protecting assets and contractual rights and protections for the company. And of course, from an HR standpoint, the employees and the workforce are you know, arguably the most important asset, but trade secrets are really also part of the lifeblood of the company. What typically constitutes a trade secret? Sometimes companies over-define what that is. Again, you can't go too broad, but things that are very specific and that are fundamental to the company are and can be, if handled correctly, treated as a trade secret. Specifics, pricing. We know that pricing data is something that can be very sensitive and very specific, and at times is even protected under the Procurement Integrity Act. So that's very important. Technical elements of hardware and software capabilities and those sorts of elements of what technology is deployed at the company can also constitute a trade secret. Sales strategies can constitute a trade secret, but they have to be treated and protected as a trade secret, or they're not going to be afforded that protection. So there have to be certain things that the company should do, which are pretty fundamental, but that are not always done. So, for example, you need to put it can be as simple as putting a protective legend on the bottom of a page of a document saying, you know, confidential, internal sensitive company information, not for external distribution, something that provides a very clear protective label or mark. Restriction with regard to distribution, provisions in your employee handbook to make it clear and letting people know what you consider to be a trade secret and the restrictions that are put on your employees so that they have an expectation of that. When we get into litigation cases and the company says, well, you know, they took these lists and they took these customers, whether or not it was actually treated as a trade secret is something that really does come up. So it sounds like a little bit of a dry topic because it has a procedural flavor to it, but it really has some very substantive impact.
Yeah, what are some typical mistakes that employers maybe make on this front in terms of either identifying trade secrets or protecting them?
They can take a technical proposal in draft form and they can put it on an attachment to an email and they can share it with companies that may be under a teaming agreement or a joint venture agreement, and then get it distributed without any kind of a request or limitation on further distribution. People in the sales department at contractors sometimes you know, with all due respect, they do a great job, and they create money, and that's what helps people get paid at the end of the month. But sometimes they're like puppies running up a hill. They enthusiastically get information and they push it out and they say, look at these great technical solutions. Um, just to make sure that I remember at a meeting that we had with one of our HR groups, one of the HR directors said, you know, she had told the sales team at one meeting, guys, you're killing me. You're getting all this information out where you're sharing some of the technical proposals and the capabilities and some of the pricing. And I know you want to lean forward and close the deal. But you got to work with me not only in terms of making sure that when we put the proposal out that the pricing is in alignment, but that we're not disclosing things beyond what we want to disclose. So it's really just talking to the team and having a strategy.
Yeah, that makes a lot of sense. And I think, as you said, thinking about it up front and then taking steps to make sure that whoever you're sharing the information with knows it's done under the expectation it's not going to be further distributed, maybe creating non-disclosure agreements with the person you're going to share it with, and writing all of that down, it is really important in this area. It made me think of one other thing, and I'm just curious if you want to comment on this. I'll give my thoughts on it, or as a reminder, I think, to the folks who are listening, who many of whom I think are Berkshire clients. So when I first started practicing law, I did a lot of handbook review, and one of the most common provisions in the handbook that I would see is, you know, a description, a policy on your company trade secrets or confidential information. So I'd like to hear your thoughts on including those kind of statements in a handbook still. But two, what I was going to say that I think is really directly related to federal contractors is those agreements almost always said employee pay was confidential, shouldn't be discussed among each other. Boy, has the world changed in the past 20 years in terms of pay transparency, just employee expectation about the ability to talk about pay. That doesn't mean it's still not confidential to the client, to the employer, but boy, has a lot changed. OFCCP has provisions that prohibit you from having these kinds of non-disclosure, these kinds of policies that prohibit pay transparency. So I guess, Seth, do you want to comment on that at all? First, do you recommend some kind of high-level policy in a handbook about confidential or trade secret information? And then secondarily, what has pay transparency done to this notion of trade secrets, especially in the area of employee compensation?
Yeah, those are two great questions. Elements of protection of proprietary information and confidentiality are things that that definitely should be addressed at a minimum in the handbook. And quite frankly, I think it would also be very helpful to make sure that those kinds of basic protections and expectations are included in your employment agreements. Sometimes they're attached as an exhibit or an addendum. I'm not a big fan of that. I think there should be one simple integrated employment agreement so that if you have to enforce it later, you're not in a courtroom flip-flopping around with a contract and 3 attachments. But yes, I would say that indeed those should be in there. And if they're not, then that should be taken into consideration by HR. I love the issue that you've raised with regard to pay transparency because it is really such a hot issue. I actually saw a statistic yesterday that pay transparency is one of the hottest trending topics on TikTok, if you can believe it.
Well, if it's on TikTok, it's hot.
I know. No, we're not as cool as TikTok, but maybe we're a close second. But yeah, it's a big deal. There are currently 8 states that provide for pay transparency laws. The most recent that's going to join the party is the District of Columbia. Effective June 30th, the District of Columbia is going to have a pay transparency law, which requires, for example, that when you, as a government contractor or as any employer, are interviewing for positions, that you have to provide transparency with regard to pay bands. You have to disclose that up front for the interview process. Also, you have to immediately provide information and access to people who are applying with respect to the availability of healthcare benefits. Those are things that are going to be provided. The new DC law also forbids the employer from asking questions with regard to applicants' wage history. So these are things that are really changing. They're already in a variety of states, Colorado, Connecticut, regionally, Maryland and New York. The law in DC with regard is going to take effect this summer. Again, these are things where if we're living in the HR space, there's a lot of activity and things that are going to be happening over the next couple of months, and pay transparency as you build a workforce is certainly going to be at the top of that list.
Yeah, and one other thing I want to mention about trade secrets, especially as it relates to HR related material, for any of you who are federal contractors and deal regularly with OFCCP, you know that there has been this longstanding Freedom of Information Act battle going on for your EEO-1 reports, right? And individual employer EEO-1 reports, which historically employers have argued are trade secret related material. And, there's some new developments in that area that if you haven't heard about them, there is a court ruling saying the OFCCP is going to have to produce all of these, that they are not trade secrets. We'll wait to see if the Department of Labor appeals. I raise this, however, because it has also raised an interesting issue, just again, about what you think is a trade secret and how you define it and how you protect it. Because one of the issues that was really identified in this litigation and in all the public reporting on this is that a lot of employers were posting some of their EEO information as part of their diversity efforts, right? And so part of the argument was, you've already disclosed this. You're not holding it as a trade secret. So that's a real tangible example of how the safeguarding of your assets is so important. Because if you disclose it, even if it's not in its full form, there's an argument, right, that you're not protecting it as a confidential piece of information. So it's amazing how you can relate these things to so many parts of HR. Should we go on to talking about how you safeguard your trade secrets? Okay, let me see if I can advance slides. There we go. Go ahead, Seth.
So I believe this next slide on safeguarding intellectual property or IP assets is something that digs a little deeper into this topic overall, because these elements sometimes are created and are within the company to be protected as an asset, as, for example, an invention. There could be hardware, software, things that are created by individuals at the company or even by 1099 contractors. First of all, and so really what we're talking about, just taking a step back for 10 seconds, is when we're talking about the idea of safeguarding assets, safeguarding your intellectual property is something that, again, is a directly related and important aspect. So when you're developing software, when you're customizing software, be it for whatever purpose, commercial or especially for the government, these are things that need to be protected. One of the elements in terms of how to make sure that these works of creation are protected is that you have a work for hire provision in the employment agreement or contracting agreement that states that all such inventions and creations are the property of the company. Sometimes people just get plugged in, start plugging away and working on something, but if there's not a work for hire agreement in place, then it could just be out the door as soon as that person leaves to work for a competitor across the street. The other aspect of if you look at our cool little logo here in terms of things that flow in and out of this space, in the patent world, patents can be filed to protect a variety of important assets for the company. And common pitfalls to avoid which includes, for example, not having work for hire clause, can include disclosure of something that is patentable before a patent is filed. So in other words, sometimes companies have a really cool software and they say, man, this is really, really cool, and it's going to kind of change the way things are done in our industry. And we're going to go out to an industry day and we're going to really just kind of put it out there and this is going to be great. Well, go for it. But file a patent, or the initial version of that is called a non-provisional patent, which is a shorter, easier way of going in and getting your foot in the door with Patent and Trademark Office, PTO. Prior disclosure of certain works, which again is a common theme here, can void your ability to go ahead and get a patent. So if you are a software company, if you are a hardware company, if you are not necessarily a software company, but you're creating a dashboard for a government contracts deliverable and it does something that's novel and unique, just think about that, because again, these are assets that are very valuable, and they form part of the basis of the overall inherent valuation of your company. One of the cool things that's also in this nifty graph is TM for trademarks. Trademarks relate to things that are, for example, word marks or company logos. Those are things that should also be protected. You can file those for protection. Also, at the agency, at PTO in the Washington, D.C. metropolitan area, get them filed, get them protected. Not real hard to get those protected, but if you don't, then they could evaporate.
Yeah, this is an interesting topic, I think, in light of our earlier comment about TikTok and social media, and how companies, and particularly young generational newer entrants to the workforce. I don't want to say young because I'm dating myself, but newer entrants to the workforce, regardless of age, who are more social media savvy than me. I think this is really something you have to think about with respect to all of those tools, right? How are you using them? What's being put up there? What are the parameters? What does that look like? So, I think you answered this question, but a question did come in, so I'll ask it. Maybe we just want to repeat or emphasize. What kinds of IP assets are most critical to protect?
I would say that the most critical kinds of IP assets to protect are really anything that you're creating, anything that you're inventing through your workforce that provides a new and novel approach to, for example, a hardware or software that can be deployed, that is an important asset that could generate substantial revenues for your company. I can discuss it because it's a matter of public filing, but we represent a company that has a unique software for how to use certain visual metrics for weighing cargo that has to weigh in order to be able to go through the National Transportation System. This is something where we filed a patent, we filed a non-provisional, and then a follow-up full patent application to protect that, because since it's a software company, that's something that's really integral to the overall effectiveness and profit of the company. Also, keep in mind that if you're a company that's growing and you want to attract capital investors, so we're going to touch just for a second on the M&A or the transactional space, people who love you may be delighted with the idea of giving you nice money, a nice big fat check, to be able to say, can I please buy into the company? Can I make a capital contribution? Can we go out in the market? Can we make ourselves available for a liquidity event? Sure. However, when you go through that process, you go through something that is called a due diligence process, where the potential investors lift up the proverbial hood and they kind of sniff around and make sure that all the carburetors are all right in the engine. It sounds like a simple process, but if you don't have these little things tidied up, everything from tight employment agreements to protection of your intellectual property, that's something that is going to inherently deflate the value of your company and going to make it harder for you to raise capital. So those are all things that kind of bring us a little bit full circle in some of these things. Another quick point that's a little bit off to the side, but when we talk about social media and handbooks, also keep in mind that social media, there are social media policies that should also be incorporated in handbooks in terms of conduct on social media, and not getting these kinds of secrets out to just go out on Facebook tonight and say, hey guys, look at this really new software that I'm coding. This is gonna break the internet. Those are things that kind of operate in their own world, but these are all things that come together so that as your company grows and you can protect the assets and inherently increase the market value of the company.
So a listener asked, how long does the patent or trademark process take? So how, and that's like asking, anytime you ask how long does it take for the government to do
Mhm.
something, that's a loaded question, but I'll ask it anyway, Seth.
Yes, great question. So the short answer is too long, but that's not very helpful. So I'll get a little bit more specific. So it depends, because a lot of it depends upon the status of the docket of the trademark office and how things are going at PTO. Generally speaking, you can probably get a trademark through and approved, hopefully within about 6 to 8 months. For a patent, you have generally a year between the filing of the non-provisional and the full patent application to get that in. You can pay expediting fees. A full patent application approval, it can take 2 years, depending upon how full the docket is over there. So your attorney can talk to you about expediting fees, which I think are frankly very, very worth it. But the sooner you get it in, the faster it comes out.
That's good advice, I think. And it's good to add it to your planning, right? So when you're thinking through all of these issues, you need to add that timeline potentially into your planning as you grow your business. So,
You bet.
so earlier, Seth, you had talked about picking a forum that is perhaps more favorable to hear your dispute.
Mhm.
And so I was wondering if we could spend a little bit of time talking about contract venue clauses. First of all, what are they? And then, how do they work?
So I think that this is really the lowest hanging fruit that sometimes the kind of the football gets fumbled. Sorry for the sports analogy with the big games coming up this weekend, but this is really low hanging fruit. Um, a venue provision is the clause in an agreement that simply says, in the event that any disputes hereunder arise, we agree that these disputes will be resolved in, for example, the state and federal courts of the Commonwealth of Virginia, or will be resolved in an arbitrator that is duly appointed by the American Arbitration Association, to be for a hearing to occur within the Washington metropolitan area. So that's what a venue clause is.
Okay.
Um, and really, the most important point to drive home is, as we say here in the slide, don't get hometown. And what I mean by that is, if, let's say, for example, you're a company in Tyson's, you're in an area that you have the most court-friendly state and federal courts in the United States. You've used the phrase rocket docket. That's a great phrase that us stuffy lawyers know, because it moves so fast like a rocket. You can get in and out of there in a couple of months, hopefully. And the Fairfax Circuit Court in state court is very organized and very predictable as well in terms of the policies and the procedures. So don't get hometown. If you have a contract, be it with your teaming partner, your subcontract, your employment agreements, what have you, have your venue in your local area, so that if you have to enforce something, if you're in court, you're not going to get hometown. You're going to be able to go across the street. You're going to have your local counsel. They're going to walk into Fairfax, who's been there all the time. They know where the coffee machine is. They know the judges. Hey, good morning, Your Honor. Great to see you again. We're here to talk about such and such. And then you don't have to go to Oregon or California or something like that. So that's what we mean by avoiding getting hometown. Your main location, your headquarters, is typically the acceptable venue. Your employees can be all over the place. And again, you can't claw back the substantive local state substantive laws for the employment principles, but you can venue all your cases here. So if you are, for example, in Fairfax County, you're kind of loving it because you were in one of the most organized and employer-friendly venues in the United States.
That makes a lot of sense. I won't ask what you should do if your hometown is California.
Well, that's a good question. Yeah.
Well, so we have about 10-12 minutes left. And I think if it's okay with you, I'd like to move on to talk about arbitration agreements,
Sure.
which I know that the focus today is on arbitration provisions, presumably in these non-competes and non-solicitations, but just in general, an employment-related arbitration agreement in an employment agreement is such a hot topic. And as I alluded to earlier, OFCCP's new scheduling letter, right? That's the letter that every federal contractor receives when you're about to be audited by the Department of Labor for compliance with all of your affirmative action obligations. That letter requests 26 items, and one of those items is your EEO policies and arbitration agreements and similar related agreements. That's brand new as of September, but it really goes to demonstrate, I think, the interest of the government at a federal level in understanding restrictions. That's how they like to characterize it. Restrictions on employee rights. This is a very coordinated effort across the government. I think this is one thing the Biden administration has done well, this one government approach to issues. So not only is OFCCP interested, EEOC is interested in arbitration agreements and employment. The NLRB has been very active in a lot of areas, but in particular in this area. So can you tell us a little bit about your thoughts on arbitration agreements and what are your tips for employers in this area?
Yeah, absolutely. I think that you've hit on a trend that I'm going to be in total agreement with you here on this. And it's frankly a trend that cuts across various agencies. I can point to the National Labor Relations Board, DOL, the EEOC. The agencies have been skeptical, especially as of late, with regard to requiring mandatory, compulsory, binding arbitration, particularly with respect to employment-based claims, or what we call so-called Title VII claims. So there has been a hesitancy and a skepticism to enforce that. And part of the reason is because the agencies like the EEOC and the DOL say, we are the federal government. How dare you say, for example, telling us at EEOC that someone cannot file a charge of discrimination with EEOC. We don't recognize that. Of course they can come in and do that. You can't contract that away. Now, these things get litigated, and again, I'm not trying not to get anybody in the weeds, but I think that the reality is that there are two reasons in a most general sense as to why I would recommend, if possible, avoiding arbitration clauses if you are the employer. The first is, you're kind of, as we're saying, stepping into an area where some of the federal agencies are pretty skeptical of those, and in certain instances and venues, they may frankly not even get recognized. But a broader and general reason why I don't like arbitration clauses is because arbitration is kind of the Wild West. And what I mean by that is you go in, you mutually select an arbitrator, and then you get what you get, and you don't get upset. There are no clear preset rules. The arbitrator has significant discretion. After the hearing and you get the ruling, absent incredibly rare and extraordinary circumstances, there is no right of appeal. You get it, you're stuck, have a nice day. And quite frankly, why should you give that up? Why not have more predictable rules? Why not have a right of appeal? You may not even need that anyway. You may have a strong case, but why submit yourself to an arbitrator who has all this power when you have these great procedures in the rocket docket right down the road in Alexandria, where you can get in and out pretty quickly? In, for example, the Fairfax Circuit Court, where you have all these great rules, and if you have a dispute, you get on the docket, and then everything's wrapped up in 14 days. Why would you give that up if you're in such a favorable jurisdiction? So if the arbitration clauses are in there, then they must be applied, because then the other courts do not have jurisdiction. But I would just caution companies to really think twice before they go into arbitration. There are some positives to it. Some people like it because it provides for a more non-public venue for resolution of disputes. There could be there could be some reasons, depending upon the situation, to look at that. But arbitration clauses are things that you don't really spend a lot. It's one of those things that you don't really think about it until it comes up, and then all of a sudden it's like, I'm in this American Arbitration Association case, and we've got this judge, this arbitrator, and I just don't understand how he's handling this thing. Well, you get what you get. So arbitration clauses are very common. Sometimes they work, sometimes they don't. But the beauty of working through the employment agreement and the 1099s is that as the company, as management, you have the ability to control these kinds of provisions that we're talking about today. So it's a good thing to raise and a good thing to consider.
Yeah, I think your points are really well taken. When I was at EEOC, it was some of the most common litigation that came up for approval by the commissioners related to arbitration agreements in employment. This is an area that the agency cares passionately about and has cared about for a long time. You know, they've taken cases all the way to the Supreme Court on this issue.
Yeah.
It's because of the things that Seth mentioned, that's their concern. One, sometimes arbitration agreements prevent you from filing a charge. And so that hinders their enforcement capability. But two, they really believe that sunshine on your issues actually is part of how discrimination is further prevented, right? And so they really dislike the fact that the arbitration process is often very confidential and cannot be publicly disclosed. That's usually one of the main reasons employers like it so much. But for me, the number one takeaway here is you have to know that if you are going to implement an arbitration program, one, it may come under scrutiny, and the government may be asking you about whether you have one, especially if you're a federal contractor. It's not going to take a complaint. It's going to just take a neutral audit of your affirmative action plan. And then they're going to go under the hood. They are going to make sure that that process is fair for the employee, and all of those things. So you want to do all that homework if you're going to implement an arbitration program, and just know that they are very, very interested in this, and just historically have viewed arbitration very negatively from if you're talking about a civil rights enforcement agency. So, well, we have 4 minutes left. So I want to ask you my favorite question at the end of a webinar. If there's one thing that our listeners should do or think about when they leave this webinar today, what is the one thing they should put on their to-do list?
Oh boy, that's both a great and challenging question. I think that the one thing that I would say to do after having joined us today is just take out the template employment agreement and see how easy it would be to tweak and fix. So for example, do you have an arbitration clause in there that can be adjusted? Do you have an attorney's fees clause in there? Meaning that, an affirmation that if you're the prevailing party and you have to go and get dragged into case, that if you prevail, that they have to pay your attorney's fees. Sometimes that is a deterrent for people to give you a hard time in court. Do you have the right venue clause? Are you going to make sure that you're not hometown? Do you have the protections in place to protect these intellectual property assets? So I think just a quick review, either on your own or with your legal counsel, are things that can be done in a very cost-effective way. I think in conclusion, it would also help you with a cost down, revenues up approach. Because if you put these provisions in a way that helps streamline the process, you will spend less time chatting with your attorney, even though I'm sure he or she is absolutely delightful and that you love working with them. But you'll spend less time in the courtroom and you'll spend more time in the boardroom because you're asserting a greater degree of control and direction over the protection of your assets, namely through these contracts in provisions that are pretty straightforward and pretty quick to put in. So that would be my recommendation. Take control, take review, and just plug them in and let them roll.
That's good advice. That is a great takeaway, I think, for everyone listening. So I just want to say thank you all for joining. I hope you enjoyed this conversation as much as I did. Seth, it was great to have you join us today. We do have our emails here, so if you have any questions, you can reach out to Seth directly. I just wanted to thank your firm for being such a great partner. And I hope everyone listening today has at least one or two takeaways that you're going to put on that very long HR to-do list. But I think this is one area that it is worth looking at, and there's nothing like the new year, right? To pull out that employment agreement, dust it off, like Seth said, and just take a fresh look at it, especially if you're in California, because you have some upcoming obligations. The clock is ticking in terms of February 14th being very, very near. So thank you all for joining. We look forward to hosting another webinar for all of you. And Seth, thank you so much. Really appreciate having you on the webinar today.
Thank you.